This is more of a fun discussion than perhaps some of the edgy and heady stuff that you all have been doing for the last 3 days. We're just going to have a conversation with Judge Shira Scheindlin. If you don't know who she is, you should. Judge Shira Scheindlin is a recently retired federal district judge from the Southern District of New York. And as it says right here, we're just going to have a conversation with her and talk about some of the things that she's done that have really created a good part of the space that we're in today. What are some of the things that she's doing? What are her thoughts about the marketplace and what's happening? So hopefully this will be fun. And of course, very much want you to have the opportunity to ask questions if you'd like. And I am hoping that this is going to work. Yes, hopefully you all have gotten your app. If you haven't, I suppose there are a few things left. This is who we are, just briefly about myself. My name is Ariana Tadler. I am a partner at Milberg LLP, where I do all sorts of litigation, principally on the plaintiff side. And over about 2 years ago, I had the privilege of launching a new business with Paul McVoy, who's our executive director of Meta eDiscovery. We had built a data hosting management and consulting business within the firm. And Paul persuaded me that it would be a great idea to pull it out and be able to service far more people, and we've done so, and we work extensively with Relativity and the entire team, which is always a privilege and a pleasure. I've been practicing for 25 years. Over the last almost 20, in addition to managing very large litigations, including one very high-profile one that was before Judge Scheindlin. I also built an e-discovery practice. So I have a team of lawyers that I have educated over that period of time to be folks that not only litigate cases, but can really do a deep dive when e-discovery issues come up. And much of that development of that practice over the last 15 years was very much due to a case called the IPO securities litigation, in which I was before Judge Scheindlin. It was a case with 55 investment banks and 309 corporate issuers, all of which had electronic information. And this was early 2000s, 2001 actually. And at the time, lawyers in my sort of driver's seat at the time had not had a lot of exposure on the plaintiff's requesting side of how to ask for data, what would you do with it if you got it, and in the end, we had the equivalent of nearly 30 million pages produced in that case. And again, this was a case that started in 2001. So Judge Scheindlin, again, most people know who she is, but here are some renowned cases that the judge has worked on. How many of you know the Zubilake cases? Okay, so for me, that was so exciting because it seemed like it was like every day that there was a new opinion. And of course, it wasn't every day because that case did go on for a period of time. But Judge, can you just talk about briefly, for you, what did that case mean for you in terms of your docket and even your career? Because it was really the starting point.
Yeah. As far as my docket, it was a routine run-of-the-mill employment discrimination case. So there was nothing exciting about it in terms of the docket. But I quickly saw that it was going to be a vehicle on which I could write about this new thing called e-discovery. And the only reason I knew about it is I had the privilege, which Ariana Tadler now has, of serving on the Advisory Committee on Civil Rules, which is the federal rule-making body that writes the federal rules of civil procedure. And they have some judges, some lawyers, and some academics on that committee. So it's an unusual composition for a federal committee. But in any event, I was on it, and we were working on class actions, because we're always working on class actions. And some lawyer in Philadelphia, I'll never forget, wrote a letter and said, "You're always doing class actions, but the future is e-discovery." And we're like, what is he talking about? What is this? So I started to learn about it just on my own. I wrote an article about Rule 34, and it got a lot of play. And then this case comes in, and it had a couple people in it on both sides who were on it. They saw the issue. So they gave me, in a way, the opportunity to write. And it was so early in the game that everything I wrote was like picked up all over the country, and people were saying, wow, that's it, that's the rules. And I have to say, and it may sound immodest, that it sort of did generate the rules changes that followed. My series of opinions really led to the 2006 changes, and in a way, eventually to the 2015 changes. So it was a great opportunity to write, and I took it. I took that opportunity and wrote on every issue that came up in that case.
And so, Zubalaki, what
Zubalake.
is
No, Zubalake, yeah.
So, can you talk a little bit about the fact that in that case, the plaintiff herself was actually active?
Yes, she was really a driving force. This was a woman in the securities business. She was really very smart. She said she didn't get promoted because of gender, which is something we're going to talk about in this hour anyway. But she was onto technology. She really got it. And she knew that there were emails hidden somewhere that were saying bad things about her. She just knew that they had gone back and forth. And so she was tenacious, and she sort of trained her lawyer, I think, and he was tenacious. And eventually they got the gold. They got the materials that really proved the case. The case went to trial. It was an enormously large verdict. It was such a large verdict that, of course, they settled rather than go through an appeal. So that's what happened. But it would never have come to that if she hadn't dug out the key documents. So it taught us all a lesson that if you know what to dig for and if you find it, that's going to make your case.
And so, of course, you talked about the fact that much of your docket was class action oriented. In those types of cases, generally you don't see the clients, right, on the plaintiff side. It's more the lawyers who are actively involved. But, of course, you did have cases where, like Laura Zublake, who was an active client. It was an employment discrimination, harassment, hostile work environment type case. What are the distinctions in cases where you have this active person versus not? Do you see anything really drastically different?
She's an exception. Most cases don't have an active litigant. They have active lawyers. Lawyers develop a certain amount of skill in this area and in the substance. But somebody like Laura Zubalake is a very unusual person. So whether it's a class action where there really isn't a visible plaintiff, or whether it's employment discrimination where there's a real person, that doesn't seem to matter. It's all about what the lawyers understand and what the lawyers have to do. It's pretty rare for the litigant to get it.
So here,
I should add, unless it's an institutional litigant,
right.
Sometimes they really do get it. So if you're litigating with the city or the state or the federal government, and I noticed one of the cases you put up there was SEC versus Collins and Aikman. The SEC was pretty aggressive about knowing what it wants. So some government agencies get it. On the other hand, 2 cases down, the National Day Laborer case, which I'll always remember, was a case against a number of federal agencies like FBI and DOJ and CIA and all of them. And they were way behind in understanding e-discovery and case management and electronics and collections and review and production. They were way behind. So that opinion tried to bring the government up to speed and say, you can't just demand this from corporations. You have to be able to produce it too. So that was an important decision in your list.
So most of you, no doubt, know that the Federal Rules of Civil Procedure were amended effective December 1st, 2015. So we're actually coming up on a 2-year anniversary of those amendments. Hard to believe. What's also hard to believe for me is how frequently I'll be out and about litigating with somebody and they are not really familiar with the amendments. You're not on the bench now, but certainly you were on the bench at the time. What was your reaction if somebody showed up and was not familiar with the rules governing procedure, or the law for that matter?
The answer is I'm never surprised by that. Lawyers don't memorize the rules. They don't even come to court with the rule book. In the middle of trial, they say objection. You say on what ground, and they say duh. And you say you might bring with you next time the rules of evidence, so you have some idea of why you're objecting. So it's not unusual for lawyers not to be very up on the rules. It takes years when you put in a rule change for them to stop citing outdated rules. But I'm talking too much about federal court. I always like to remind an audience that most litigation is in state courts, and there are 50 states with different rules. And so for those of you in the audience who are litigators, and I don't know how many of you are as opposed to on the technology side, but what goes on in federal court does not necessarily go on in state court at all, and we tend to focus on the federal rules. But be conscious when you're different jurisdictions to know what their rules are, because on the e-discovery side, they may be completely different than the federal, completely different, and you're going to have to litigate to the standard in that state. So,
How many of you are practicing lawyers?
a good percentage here.
Okay. And how many of you among those lawyers are plaintiffs' lawyers? Okay. And how many of you are technologists?
Lots and lots. Good.
Is there any other category that I'm missing?
Yeah, well, you didn't say defense lawyers, but it's the rest of, yeah.
Non-practicing lawyers. Okay. Okay, great. So, the topics that we're just talking about is just to talk a little bit about some of the evolution of the law in terms of Judge Scheindlin's role, but also, what is she doing today? And I just wanted to touch a little bit more on a couple of these cases so that you had some familiarity with them, but also the fact that one thing I can say, and I can literally do a testament to this because I was before her, is nobody was a presumptive winner when you went in before Judge Scheindlin, okay? You had to make your case, and depending on how the facts and the law played out, that was how the ruling was going to play out. And the reason I like this series of cases is you see for SEC versus Collins, there the government had an obligation to search and produce from its own ESI, similar to private litigants. A lot of people were surprised by that case. There's sort of, I think people sometimes just presume, there are different rules for government and regulatory agencies than there are for the rest of us. No, the rules apply, and Judge Scheindlin took that very, very seriously. I don't know if there's any further comment you'd have on that case in particular.
No, not in that case in particular, more in the National Day Laborers one, because there were so many federal agencies who were not up to speed. And that case involved FOIA requests involving secure communities, which had to do with immigrants. It was a very interesting case. But these agencies were saying, we can't do it, it's too expensive, we don't have the tools. And the answer is, you've got to do it. You have an obligation. It's part of your being in the public sector, and you owe it to the public. So you're going to have to get up to speed. You're going to have to spend the money. And so that was really, in a way, more of a landmark ruling than some of the others, because we all have to play by the same rules. And the government, whether it's federal, state, or local, are a huge percentage of litigants in federal courts and in state courts.
And surely that's true that we all have to play by the same rules, and that's you see that in pension committee where the judge issued sanctions on the plaintiffs for not properly preserving and producing ESI. That, I will tell you, was quite an earth-shattering opinion for many plaintiffs' lawyers who had not spent their time learning up. Certainly I and Paul had been out there sort of proselytizing, saying, get up to speed. You really do need to understand that the rules apply to everybody, and while it may be true in asymmetrical cases like class actions or mass torts or personal injury cases, the individual plaintiff or even the class representatives might seemingly not have a lot of information. At the end of the day, the rules are the rules, and you have to at least go through the steps that are required to determine what does your client have, what efforts need to be engaged for purposes of preservation, how are you going to produce the information, are you going to engage the other side to talk about, are you producing native files, are you producing PDFs or TIFFs, are you going to preserve the natives so that if there's an issue, the same kinds of conversations that we would necessarily be having with the other side in terms of what their expectations and our expectations are. I
think the importance of pension committees, up till then, everybody on the defense side thought of sanctions as a weapon against them. But it became clear after a while that at least where both parties have a lot of records, the rules, again, have to apply equally to both sides, and any producing party is at risk if the producing party doesn't do it right. So that was really what the point of the pension committee decision was. There are producing parties, there are requesting parties, and I don't look at it as plaintiff and defendant typecast. It's who has the obligation to do what. And it tried to set some standards that apply to both sides, to producing parties and requesting parties.
And then, of course, Sekisui was a very timely case because that was really coming right at the time when the rules amendments were about to come down to bear. And there, the judge had issued sanctions on the plaintiff for failing to properly preserve data, and she used a three-part test that came from a very well-known case called residential funding. The rules governing sanctions have since changed, but when that case came out, I can promise you there was quite a bit of discussion.
Well, because the rules that were being put out for public comment, Rule 37E, the revised sanction rule on the federal side, kept talking about willful, and that draft went nowhere in the end. And finally, the language was intent to deprive for the heaviest sanctions, but for all the other remedial measures, we don't say the S word anymore, but for remedial measures as opposed to sanctions, there's a whole lot of remedial measures that don't require intent to deprive, in fact, don't require any state of mind. You don't have to be negligent or reckless or grossly negligent. It's really quite interesting. The vast bulk of remedial measures apply just when somebody's prejudiced from the loss of information. Forget about intent to deprive. That only applies to a very few measures. So the 37E that actually got promulgated, I think, is a reasonable compromise. But it took a lot of public comment. It took a lot of letters written to the committee. It took a lot of discussion and drafts. That was a last draft out of many drafts. I think I can use we lightly, but came out with a pretty decent compromise in 37E. Again, it's not in effect in all states, and a lot of judges don't seem to yet understand it fully, but it's there, it's on the books, and it's going to have a good life of its own. So this may end our discussion of e-discovery, and I know that you're here for that purpose, but we thought it would be kind of fun on your last morning to sort of broaden the discussion to non-e-discovery topics, just to, I don't know, change your focus for 35 minutes or 45 minutes, whatever we have left. So.
Right. So how many of you are familiar with Judge Scheindlin's decision about stop and frisk?
Oh, good. Well,
Okay.
not good. More of you should. Raise your hands higher. There you go.
So before we really even get into this case, some of the other notable cases that you might not know about is that Judge Scheindlin actually presided over 3 trials relating to John Gotti, Jr. There was the Peoples versus Fisher matter, which was an $80 million settlement involving the misuse of solitary confinement. And then also U.S. versus Awadallah, which dealt with a material witness after 9/11. So Judge Scheindlin really had this really robust experience sitting on the bench. You know, it wasn't as if she just presided over class actions or, or employment cases. People think about her, of course, with respect to the Zuba Lake. I call it the trilogy, but it's more than a trilogy, right? But here it is. I mean, she was dealing with a very, very heavy criminal docket. Most people don't realize that, particularly our federal judges that we focus on, and we're always thinking about our e-discovery world, that must be where they're spending their time. So many of these judges, especially in the metropolitan areas, their criminal dockets are really heavy. So can you talk about that first, what that docket was like for you and how you would manage that criminal docket versus cases that we all felt were so important, but obviously the issues are so different. And then let's talk about the stop and frisk opinion and what was that like for you and how did that, take you through the evolution of that case?
Okay, so you've asked a few questions at once.
I know.
I know.
Because
so
now I get to be in charge.
Yeah, so I'll try to do them in order. The criminal docket differs by jurisdiction, so all around the country the docket can be different. If you're on a border state, all you do is border people who are crossing illegally and you're sending them back. That's not what we had in New York. In New York, you get big fraud cases, you get terrorism cases, you certainly get a lot of drug cases. But since I was on that bench for 22 years, I figured out that I probably sentenced between 1,500 and 2,000 people. That's a lot of sentences. So you're running 2 sentences a week, 50 weeks a year for 22 years. You're spending an awful lot of time doing that. The depressing part of that is that so many of the cases were drug cases. And I had been an assistant U.S. attorney, which means a prosecutor. Nothing changed. The war on drugs was a huge failure and probably is still a huge failure, although now we're talking about the opioid epidemic, and years ago we talked about the crack epidemic. But the bottom line is that this country, as you probably all know, incarcerates people at a greater rate than almost any other country in the world. And we do that because our sentences are too high. And what is it achieving? Nothing. Is it deterring any street dealer? No. Partly because in some neighborhoods, that's the only way to make a living. We just have a society that has not dealt well with the drug war and the drug problem. So it was depressing to sort of be part of the drug business. I used to say I'm in the drug business because every trial, every sentence, every day was yet another drug case, and it really wasn't changing except for the names. So that was a discouraging part of the docket. But once in a while, you do get the opportunity to write what you think is a very important opinion and to make an important ruling, and you cited a number of my cases. Most of them that you cited are civil cases, but the only other criminal one you mentioned was Awadallah, and that was a really important case. This Arab-American, I guess you might say, man was arrested in California because he knew the hijackers. He was roommates with the 9/11 hijackers, so they arrested him as a material witness, and they dragged him across the country for about 2 weeks, which with every stop being strip searched and subjected to abuse, which he really was able to testify to. They could have put him on an airplane and flown him to New York where a grand jury was sitting, but instead of flying him, they took him the slow way, I suppose, to wear him down. And then they put him in a grand jury to testify, and they put him in the grand jury in shackles, kept him incarcerated. This is a material witness, supposedly, who did nothing. And the big question that he failed was, can you tell us the names of all the hijackers, first name and last name? He said he forgot the last name of several of the hijackers. He knew all their first names. By the way, all the names by then had been in the New York Times, so we all knew the first and last names. And then when he failed to repeat the proper last name, he was indicted for perjury. And I drew the case, and he was tried for perjury. And the first jury, after hearing the case, was a hung jury. I talked to the jury. They were 11-1 for conviction. But that's a hung jury. So it was retried a year later. And a year later, the country was in a very different mood. And with the identical evidence, the identical lawyers, he was acquitted. That means 12-zip. So we went from 11-1 for conviction to 12-zip for acquittal. So it was a very fascinating case. And I wrote a number of opinions that I'm proud of in that case. But I'd like to turn to the civil cases, if that's okay, because they were really very important to me. So the stop and frisk case is probably the case I'm proudest of in all my years on the bench, including Zuba Lake. This was a practice in New York of stopping people with basically no reasonable suspicion, just to terrorize them, just to see if they maybe had guns or drugs or whatever. But the cops were abusing it, and they were doing racial profiling. There was very little doubt about it. It was provable from the statistics. They stopped minorities far more than they stopped any other group, and they found very little, if anything. I mean, the rate of seizure was less than 1% on guns, and not much better on drugs. 90% of those they stopped were basically let go after the stop. And for those of us who are never going to be stopped, maybe we can't appreciate what it's like to be stopped, that you go to the store to buy milk and come home, except then the police stop you and you're hung up for 30 minutes in front of friends and family, and you're maybe frisked for no good reason. It's very humiliating, it's very disturbing, and there were people who were stopped over and over again. Worse than that, as you know from being newspaper readers, these stops get out of control. And sometimes they end up with police shootings. So it can end up in violence. It's a bad experience, and most of us will never experience it unless we are members of these disfavored groups. Anyway, I found the practice unconstitutional as practiced. The Supreme Court allows stop and frisk, but it has to be based on reasonable suspicion, and then for the frisk, even a higher standard to believe that the person is that the police officer is in danger. So it isn't supposed to happen without those legal standards. And when I ended the practice, the mayor and the police commissioner said, New York's going to blow up. What happened, in fact, is that stops went from a high of 656,000 a year to 20,000 with no rise in crime. That was very satisfying to me, because had crime really jumped, they would have said it's all the judge's fault. And that's what's hard about judging. You have to do what you think is right, but you take a great risk. As I said, had we suddenly become Murder City, I'm sorry to say we're here in Chicago, but had we suddenly become Murder City, that would have been very bad for me. But in fact, with those stops dropping by 95%, crime didn't go up at all, which shows it was a failed practice. All it did was to create distrust between the minority communities and the police. So now the good news is there's been a reform effort that I required in my so-called remedial opinion. I appointed a monitor, I appointed a facilitator. Now the communities and the police are doing better. There's something called community policing. The police are getting better training. So New York's been in good shape. We have, other than the Eric Garner chokehold case, we really haven't had one of those police shooting cases, and we're grateful for it. But you know that around the country, there's a great need for more training of police, and I'm only concerned that this administration that we have now might roll the clock back, but we'll see. At least they can't do it locally, so they can only do it on the federal side. So that's I could talk more, but I won't do it because I want to talk about a couple of the other cases very briefly.
Well, but I am going to make you talk a little bit more about it, just because one of the things that I think most people, they just are not sensitized to at all, is that judges are human, right? And there is actually an alienation that happens for judges when they take the bench. Whatever your social circle was, once you go on the bench, if part of your social circle were lawyers, now there has to be a distance, right? Because you have to be careful about, any appearance of conflict, et cetera. Well, the reason I talk about that sensitivity is because this case was hugely controversial. When Judge Scheindlin issued this opinion, there was so much writing about it.
All hell broke loose.
All hell broke loose.
Right.
And for me, it was well after the fact, and I realized even I had lost some sensitivity because I've known Judge Scheindlin for a long time. We're friends today, and that relationship built over being a litigator before, but also getting to know each other well. And the fact that people didn't think about that controversy and all of the chatter and what was happening, the New York Times and, the appellate level. And what did that feel like for you?
It wasn't easy. You have to develop a very thick skin. The press was parked in front of my home. They found out where I lived. They would film me coming into my home and out of my home. They would stick mics in my face. It was really kind of awful. But as long as you're proud of your work and you think what you did is right, you get through it. The press was very supportive, I would have to say, in New York. Most of the press. There was some right-wing press, both television and newspaper, that was attacking me personally, and again saying the city's going to blow up and all the victims, it's going to be on her head. But you take the slings and arrows and you hope that what you did was right and the best decision that you could come to. So it's not easy. It's not easy to be there, but hopefully the judges are up to the task. The solitary confinement case was very satisfying. This started out as a pro se case. The fellow didn't even have a lawyer, and he wrote one of those handwritten complaints, and he said, I got stuck in solitary for 2 years because I had documents in my cell that I wasn't supposed to have. They were actually his legal papers, and for that he was punished with 2 years of solitary. And I remember my law clerk recommended dismissing the case. She said, I don't see a constitutional violation. I said, no, there's something about this case that troubles me. How can you be stuck in solitary for 2 years for that? That certainly sounds like an Eighth Amendment violation to me. So I let the case go forward, but then I helped find counsel, because judges are allowed to do that. And eventually the Civil Liberties Union took the case, and eventually they worked out a huge class action settlement that stopped solitary confinement for juveniles, that put limits on the amount of solitary you could give for certain types of offenses, so it was tiered. So for a minor offense like papers in the cell, you couldn't give more than a week. For a major offense or a different kind of offense, you could give 2 months. For a major offense, maybe a year. But even the conditions in solitary had to be improved because they were so awful. I don't know if any of you have seen movies, but I've seen some television movies. It's frightening what a solitary cell is like. People go mad. They do lose their mind. They go insane. And you can tell this from very sophisticated people like Senator McCain and others who have been kept in terrible conditions will describe how you slowly begin to lose your mind. And this is what happens to people, especially kids. And there is this well-known case in New York now, Khalif Browder. You may have seen a TV documentary. And he just ended up committing suicide. I mean, just was so destroyed for being kept in solitary. And by the way, the Khalif Browder case was pre-trial. He wasn't even convicted of anything. He was charged with having stolen a backpack from somebody, which he said he didn't do. So he refused to plead guilty. And in not pleading guilty, he was kept in solitary pre-trial. and eventually, as I said, he committed suicide. So there was a lot to reform, and again, one is very proud if one can make a difference, and the solitary confinement system in New York, anyway, really was reformed through the Peoples versus Fisher case. So the Gotti case is just more fun. There's nothing really to say about it. I tried it 3 times because each time the jury hung. And it was tried and tried and tried in my court 3 times, 3 hung juries. So then the government got the bright idea, okay, we won't try the same case anymore because we really think that judge isn't with us. So let's indict him with a slightly different charge and we'll get a real judge. So they got this guy who's really tough on crime, and guess what? 4th hung jury. So that was the John Gotti Jr. story. He never was convicted in the Southern District. After 3 with me and 1 with this tough guy judge, it still was all hung juries. Okay, not a greatly interesting story. I'd rather turn to the next slide.
But no doubt a great cast of characters throughout.
Oh yes.
That.
Oh no, he was a character. Junior was Junior, and his mother, who was John Gotti's widow. They all were in court. It was all a riot. Okay. And the witnesses were right. All the cooperating witnesses were mobsters themselves, and they would get on the stand and say, "Yeah, well, I blew away 7 or 8 guys, but Junior was involved in gambling." Like, you got to give me a break. I killed 7 people, but Junior was involved in gambling. That didn't really hold up. No wonder it was a hung jury. Okay.
All right, so now we're going to be talking about some of the things that Judge Scheindlin is doing now. She's left the bench, and for those of you that I hope do read the New York Times, Judge Scheindlin recently wrote a really fascinating op-ed piece that got quite a bit of traction. The judge is really very regularly a topic of conversation. She tends to generate a lot of conversation on all sides. On the bench it was both sides of the V. Now it can be just depending on where you sit in terms of your politics. Could be separate and apart from your politics, just what your personal philosophies are. And so let's talk about this op-ed, talking about why, the distinction between men and women and their roles as lawyers, what kinds of positions are they attaining. And this article was really so timely for me because I'm involved in a lot of mentoring of women. I'm also involved in a big organization of women trial lawyers. And I know it's hard to believe in 2017 when you have law schools that are basically 50% men and women. Sometimes the women are more of the population than the men. But the fact of the matter is that oftentimes women are not being put in leadership positions in litigation. And Judge Scheindlin put her finger right on that and really opened a dialogue very, very publicly. So can you talk about that?
I can, and I want to say to the audience that I did as quick as I could head count of who we've got here. Maybe 15 women, maybe 20, and a lot of white males. So I have to bring the white males into this conversation. And I found out the best way to do it is to remind you that you have wives, daughters, and mothers. And a lot of daughters these days are in the law. Every time I bump into a white male lawyer, he says, I have 3 daughters and one of them's a lawyer, so I really care about what you're writing. So please stay with me and just don't say, oh, this is just for the ladies in the audience. It's really not. It's for all of us. And we need buy-in from the men and the women if things are going to change. So here's the story. You stole some of my line. Women have been,
Sorry.
That's okay. Women have been half the class for 25 years, which means there's no pipeline issue. That's a code word. Throw it out. There's no pipeline problem. But once they get into the practice, they're not getting the same roles as the males in the courtroom or in their firms or in management, and it's still tougher. And we have to look at what can be done or why it's happening. Now, I realize there's work-life balance issues. Society doesn't change overnight. Women generally take more of the role at home. Okay, that's a good thing. It's good for the kids, certainly, that are being raised. But they should be able to re-enter and pick up right where they left off. And I think that the younger men are certainly more supportive than in an older generation about sharing those responsibilities. But it's in the courtroom, what we're seeing is women not getting the speaking roles. So we did the New York State Bar did a study that I helped design where we had judges actually note who was speaking in front of them. And we found out some really interesting things. If it's the public sector, again, that means federal, state, or local government, then the lawyers were pretty much half women, half men. But once it was private, no way. The private sector was not hiring women. So the clients are not stepping up and doing what they're supposed to do, or their firms, the firms that are servicing those clients, aren't. So some clients are really making a difference now. They are insisting on diverse teams and diverse relationship partners, and they're saying we won't even select a firm that doesn't have diversity, or we won't pay, or we're going to reduce our bill by 10%. I don't know if you've been seeing this, but a number of big firms are really stepping up. So I actually see the clients as being a little ahead of the big law firms. The big law firms have institutional problems where they pass along the client to the next generation of people who look like them. And it's very hard for women to get those clients. So what is the solution to all this? First of all, when I speak to audiences, I say the women have to be more aggressive. There's nothing wrong with being aggressive. You have to learn how to help yourself by asking for the best assignment, asking for a speaking role in court, asking to be first chair, asking to take the deposition. It's not easy. Now that I'm in the private sector, and we haven't really talked about that yet, but when I left the bench, I joined JAMS, which does arbitration and mediation, and the hardest thing of all was to say to somebody like Ariana, who I've known for so long, can you help me? Can you help put my name down for possible arbitrations and mediations? It's not easy for me after being a federal judge for a total of 27 years to ask for help. But if I don't do it, who's going to do it for me? And that's what I've learned, and that's the message I would give to everybody. And this goes for junior attorneys too. You need to ask for the opportunity. So whether it's young men or young women in law firms, you make your own opportunities. So on the judge side, we've encouraged judges to pass some individual rules, and some have, that say I'm more likely to grant oral argument requests if a junior attorney argues. And one of my former law clerks, a male, said, your new rule was great for me. My senior partner said, you're young, you haven't argued a motion, why don't you argue a motion? So it was good for everybody. It wasn't just gender, it was good for everybody to try to encourage more people to have opportunities to speak. So we have to change the culture, and slowly it's happening, and I think this op-ed was helpful in stimulating the conversation. So I'm happy about that too, but I don't want to miss the next slide,
No.
which I'm excited about.
We are good. We have till 10:45, correct? Or 10:30?
I thought no, you're right. 10:45.
10:45.
Oh,
right.
we have
So
plenty
we're
of time.
good. We have plenty of time, right? Because
Chill. I'm going to chill.
So I find this topic, obviously, about women so fascinating. The judge talked about even family dynamics. So what most people don't know about me is that my husband actually was the stay-at-home parent. He raised our two boys. He actually has a very interesting career. He's a stuntman, a screenwriter, an actor, a parks commissioner, but he was the person who was the boots on the ground at home. And at the time, this was in the 90s, going into the early 2000s, that was really unusual. And, we were just with some friends over the weekend, and we were sharing some stories about the challenges that he faced in really being sort of distanced from the moms who were in town raising their kids. So you have those kinds of challenges when we're talking about let's get women out there and let's recognize that the dynamics of family raising and just personal relationships have changed in terms of who's doing what, who's contributing what. And then getting to the, how do you promote women? So most people out there know that I do a lot of work to promote women and mentor women. But what's really interesting, and I think is important for this kind of conference where we're talking about technology, is that in many ways technology has helped, but in some ways it's actually created a little bit of a problem. And why is that? We're seeing more and more people working remotely. Well, if you work remotely, you don't have what we traditionally call FaceTime. If you don't have FaceTime, the person who's the more senior lawyer might not really have a good sense of how qualified are you, or will you be successful if I push you out there to the podium, et cetera. So Judge Scheindlin could not be more right when she says there is this aspect of self-promotion that is required. And I regularly say, not only to the women in my office and in our company, but also to the men, if you want an opportunity, you need to step up. You need to make yourself optically exposed so that we have a sense of what's driving you, what are you interested in doing, how would you like to grow? Because the world is a really busy place. We're so focused on what are our 1,000 to-dos that we're trying to check off and all those emails that we're trying to get through that we're forgetting sometimes to take the extra time to mentor. And Paul and I were just having a discussion about our company and how much more mentoring can we be doing, making the time. But we also need people to step up and remind us that they want to be heard, that there is an opportunity they're looking for, or there's a skill set either that they have or that they'd like to develop. And so we need to remember to get ourselves away from the technology a little bit, to remember about just, human nature, human civility. What are we looking to do to evolve? And one of the things that I'm sure many of you have seen is generationally, we're seeing a change in how people communicate. And I don't just mean lack of person to person, right? So I have a 17-year-old and a 20-year-old. There's a lot of time that I've seen them in the same space or the same room, and they are talking to a friend, only they're not talking to the friend, they're talking to the friend, right in the same space. So we have to work to get away from some of that, and we also have to work to be mindful of how do we communicate. A lot of younger people today are not communicating as clearly as we're accustomed to. They're not using good grammar. They're not being clear in what they mean. I just recently was asked to objectively look at a series of emails, not litigation, just a series of emails. There was a dispute between two sides of a contract, and they were saying, they're not hearing me. And I looked at this particular communication which was written, and it was with a period at the end of the sentence. Only the person who was writing it was writing in sarcasm, and it was really a question. And I said, you're not hearing each other at all because you're not talking. You would have been so much better off, and this is supposed to be a collaborative relationship, you would have been so much better off to have said, this is an issue we need to talk about in the email, and pick up the phone, right? So how do we do that? If we want to promote women, if we want to promote younger people, we've got to make sure that we're better communicating with them and really engaging them in how they can communicate better so that those of us who are older actually hear them. And what is it that drives them? What's of interest to them?
Well, and I want to add something about a diverse society. It's not just that I'm here to say we need opportunities for women or we need opportunities for minority groups, which we haven't really included in this conversation yet, and we should. But we should talk about the benefits of diversity. It's not just that we ought to do something, it's actually good. There have been studies that show that diverse teams make better decisions. And this has been studied, let's say, in arbitration. When you have a diverse panel, you don't have groupthink. It's been studied on boards of directors. When you don't have an all-white male board, you get better decisions because you get diverse perspectives. After all, who are the customers and consumers of big companies? They're completely diverse. This is a very diverse country. We're not Sweden. We have a very diverse society. And so including people with different points of views is the way to make better decisions. We think about a jury. Now we have, post-Batson, we have very diverse juries. I don't know if you know what Batson means, but you can't strike people based on race or gender anymore. So our juries are very diverse. They're ready to see a diverse team of trial lawyers. That's what they expect to see. The bench, by the way, is 33% women because the federal bench is 33% women. The bench all across the country is 27% women. But the reason the federal numbers went up so high, both for women and minorities, is because of President Obama. That's the kind of judges he picked. He really went out of his way to pick diverse judges all throughout the country. Again, I think we're going to fall back on our statistics in the next 4 years. There's no doubt about it. I've been looking at the early appointments of this administration. Let's just say they aren't the same as what President Obama would have picked. So we're going to fall back a ways for a while anyhow, and our judiciary will shift back. But the point is, we make strides when people intentionally realize the benefits of having diversity in our teams. Whether that team is a litigation team, a technology team. In fact, speaking of technology, I know I'm wandering around, but technology, and it's going to segue well to the next slide. A lot of the heads of a lot of the companies are immigrants and diverse people from all kinds of different cultures, and they have great ideas and have built great companies. So we have to keep in mind that this is all for the greater good, and it's not just preaching, gender equality for the sake of it. It's actually beneficial to all of us.
So now we're going to turn to something that's very exciting. Since the judge left the bench, there are two specific things that she's really also been focused on. One is the American Immigrant Representation Project, which she's formed with the American Immigration Council. And there's no point in my stealing your thunder. Talk
Thank
about
you.
it.
Oh, okay. Okay. So when I left the bench, people said, "What did you do that for? What did you have in mind?" And I said, "Well, I've done that for a total of 27 years. I want to try to see what other impact I can have. I want to get out there in the world and be able to write and be able to speak and be able to do things." So one of the things that had been concerning me in the last couple of years on the bench was the whole problem of immigrants, immigration, and immigration law and how they're treated. Well, things went downhill from there, shall we say, after the November election. You could tell that there was going to be a big ramp up, sort of an anti-immigrant focus, an effort to deport more people, the tarring of everybody as rapists and murderers, which of course isn't true. Most immigrants are, as I said, very productive people in this country, but you could see where it was heading. So I got this idea that we needed to marry big law to the effort to provide representation to people in detention, because that's the most vulnerable group. They don't have lawyers, and the detention centers are purposely placed in remote locations. So the local bar cannot really service people in detention who can't afford a lawyer anyway. So you'd have to do it pro bono, but the detention center is far away, and the condition in these centers are terrible. These are primarily run by private prisons, which again, the Obama administration had tried to end, but we're back in the era of private prisons, and they're for profit. So they're not spending money on medical care, on education, on bilingual facilities. They're trying to make money and spend as little as possible. So people are held in terrible conditions without lawyers. And so I tried to raise sort of an army of volunteer lawyers who would take on detention cases and represent immigrants in detention. And it's working. We're building. We have over 150 volunteers. We've represented people in detention now in maybe 5 different detention centers. We've had some good results. We won an asylum case yesterday. But we're trying to say to people, you need to give back. I mean, I know you're all in-laws lawyers or technology supporting lawyers, but are you doing enough for your society and your country in terms of helping out and doing what you can to make a difference? And everybody can do it in their own way. I'm not suggesting you need to do it in the biggest way, but whatever way you can do it. If you can give money, fine. If you can give time, fine. Whatever you can do is needed in society. So anyway, I decided to focus on immigration. What we learned right away is that if you have a lawyer when you're in detention, you're 14 times, the slide is a little hard to read, but you're 14 times more likely to be successful in remaining in the country if you have a lawyer. The notion of a prior conviction is something, a really interesting topic that we don't have time to explore too much. But, the president said that I'm going to get rid of all these murders and rapists. Well, a lot of these prior convictions are things like open bag, with a beer, which again, with most of you had a brown paper bag with a beer, nobody would care. But if a person is of color, they're more likely to be stopped for that. They're more likely to be charged with open carry, and then they have a misdemeanor conviction, which can get them deported. It might be having a driver's license that expired. It might be having taken a Social Security check or something, or a benefits check when you should no longer have been taking the benefit. These are they're misdemeanors, but they're not so major that it should tear apart families. And you've all been reading about the DACA problem right now, which is the Deferred Action Against Childhood Arrivals. That's being fought in the court. You've certainly read about the travel ban. That's being fought in court. The limit on refugees was lifted yesterday. It expired 120 days, but now there are new restrictions for 11 countries. So there's just so much to talk about in the immigration space. And I left to try to make a difference, as well as just be in a different space. So I'm glad that you let me talk a little bit about the AIRP project. And if anybody's interested in pursuing it further somewhere, I'm sure you can find my email address.
Yes.
I'm happy to do that. Okay.
Okay, so next we're going to talk about the fact that Judge Scheindlin obviously has not left the practice of law at all.
Nope.
Since leaving the bench, she's joined JAMS. And how many of you are familiar with JAMS?
Oh, good.
Oh,
Lots of
very
you.
good.
Lots of you.
So I would say that JAMS is really the top organization that's utilized for purposes of identifying and securing a mediator, an arbitrator, a special master. And I was so thrilled to hear that Judge Scheindlin chose to do this because certainly in the cases that I work on, they tend to be many years long. They tend to be complex. To the extent that you do go into settlement, and in the prior panel that we did, Judge Scheindlin talked about how few cases actually really do go to trial of that nature. And so the fact of the matter is you really, just as much as you want to have a good judge, you really want to have a great mediator, arbitrator, special master who is going to engage. Somebody who's going to listen, is going to do some of their own research, is going to understand what the facts are, the law is, how do those things interface and interrelate. And so can you talk about what prompted you to do this? And are there specific types of cases that you really do enjoy working on? What is the expanse of cases that could come to you so that people know that this is what you're doing?
Well, thank you for allowing me to make a pitch. As I said earlier, it's hard to do that, but so be it. She's allowing me to do it. But why did I do it, I guess, is the first question. The ADR system is really an alternative justice system. A whole lot of cases are in ADR, and they're not in our courts. So one would hope that the access to good justice in the ADR system is at least as good as it is in courts, and so many cases are required to be there by contract. I know you know about consumer contracts that make you arbitrate almost every grievance you might have. So there's a big system out there that is providing justice. So to link it back to one of the prior slides, again, women and minorities are not doing very well in ADR, sadly. In international arbitrations, women are 4% of the arbitrators, a pathetic figure. Domestically, 15% of arbitrators, pathetic, given that they've been 50% of the profession for so long. Mediation a little bit better, although they're tracked into certain subject areas. So if you look at the statistics, you'll see a lot of women mediating employment cases, mediating family law cases, but you almost see no women mediating securities law cases or big commercial cases. So anyway, I hope to do it because I had hoped that I might be able to be effective as a special master in civil rights type cases, voting rights, or police cases. That hasn't happened yet, but I'm still hoping that that kind of case will come my way. In the meantime, of course, I want to be busy, so I'm looking for commercial cases, looking for securities cases, willing to do almost any kind of cases, including special master work. But I really would be troubled to turn this into a pitch session for me. Basically, the idea, though, is that because it's an alternative justice system, I just want to make sure it's a good system and that there are good people doing the work and that you have ways to identify good people to retain. So I don't really feel comfortable saying much more about it than that, other than, yes, I'm with JAMS.
But I will say something more about it, which is this. So in the prior panel, when we were talking with Judge Scheindlin about technology and e-discovery, et cetera, we were talking about the fact that certainly in the federal system, many of the cases are often, for the discovery issues, they're put to a magistrate judge. My experience with Judge Scheindlin that was not the case because Judge Scheindlin was really engaged in the e-discovery space. What I have found is that depending on the court that you're in across the country, you may have magistrate judges that are very learned in the area. The Southern District is a very good example. But then, you can have jurisdictions where there is turnover, and to the extent that you have even the magistrate judges who are not that familiar with the issues, especially when you're driving into technology, when we're talking about TAR, when we're talking about what we're here for purposes of this conference, that's when I say to myself, well, I want to know that there are some people out there that if I don't feel confident that I'm going to get really justice in terms of the opinions that I need, I may want to say to the court, you know what, this is a case that the issues for discovery are so intense, I want a special master. I want us to go outside. And ironically, in this IPO securities litigation case that I had before Judge Scheindlin, there actually were 3 appointed special masters, all per Judge Scheindlin's suggestion at the time, so that we would have resources of people who already were experienced and had really good knowledge sets on some of what we then thought were cutting edge issues. Now they're old school. And so to me, the fact that you have somebody like Judge Scheindlin in a place like JAMS, that if you need a special master, you know that this is a person you can go to. And we're seeing some other judges who are retiring who are doing similar things. But it's just something to keep in mind. The last slide we have actually is the fact that Judge Scheindlin recently had an article about the use of special masters in complex cases. It's so important to obviously get the word out about what it is that you're doing, but also teach people why might you need a special master in a case? Why might it inure to your benefit? And in the IPO cases, I can honestly say, both sides were very amenable to the use of special masters because the docket for that case was so heavy. So in any event, that's really kind of the close. I don't know if you had any closing thoughts, but I was going to otherwise ask if anybody had questions.
That's what I was going to do, too. I was going to say, I think we do have a few minutes, and it's always fun to see if people who have been listening to the two of us talk for an hour have a question or two that they'd like to raise. If not, I will make a sort of a closing statement, but would be happy to take questions if somebody has any. Big group. Lawyers, talkers, yes, Paul?
There was an article in the New York Times yesterday about judges' post-traumatic stress at having seen and heard violent things for so long over their careers. Just want your thoughts on that. Has that affected you at all, or have you handled some really?
Yeah.
Let me just repeat the question.
Yeah, okay. He asked about an article that was in yesterday's Times about judges suffering from post-traumatic stress from having to observe and see so much violence or hear about violent conduct in the trials that they supervise, and he asked whether I felt that had happened to me. I did not see the article, that's the first thing, so I didn't read about it. But no, I don't think that happened to me because most violent crime is tried in the state courts. There is some violent crime, usually related to a drug case, that might involve murders in the course of the drug conspiracy that we see in federal court, but not a whole lot. You know, your basic assault case, rape case, the really murders, I mean, they're in state court, and they see a lot more of that. I did have a friend who was a family court judge, and after about 15 years, he said, I couldn't take it anymore. You listen to child abuse cases, and it just wears you out, wears you down. So I can understand how that would happen, but I didn't see the article. I did see a hand way back in that corner. Yes, sir.
Yes, sir.
Hi. It seems that with kind of the diverse experience with social issues that you've had, how often during your career have politicians at whatever level maybe reached out for your take on certain issues to form their own kind of policy decisions? Would you say that's typical of?
You know, judges are pretty limited on what they're able to say while they're on the bench. They can talk about general subjects like sentencing policy, and one of the judges in the Southern District, Judge Rakoff, regularly writes on sentencing issues. Judge Posner, who recently stepped down, wrote on many such issues. So you can comment in a general way, but you can't comment on the case before you. So it was nil. The answer is no politician ever reached out, but the media reached out regularly for comment on general issues, and there are many judges who are willing to give general comments back. And I think it's helpful. I mean, I've spoken a lot about the relationship of media and courts. It's actually helpful to educate the public as to what judges do, what the decision-making process is, why they have to make some of the decisions they make. For example, bail is completely misunderstood. I mean, the idea of the public is, why would you release a guy like that, a bad guy? Well, it's called the presumption of innocence, first of all. Maybe he isn't the bad guy, maybe he's the wrong guy, maybe they arrested the wrong person. And also, that's not the standard in bail. The bail is that he'll return to court and that he's not a risk to the community. So people need to be educated as to why certain decisions are made. Also, nobody understands suppressing evidence. Why is evidence suppressed when it's right there in the car or on the person? Because we have a Fourth Amendment. And if it's seized illegally, we say it's more important to stop the illegal conduct by the government, even if the criminal goes free. That is an old principle, and we respect the Fourth Amendment in this country. So I think that there is contact between the media and the courts, not so much politicians and the court. I must say, once we're there, they don't much care about us one way or the other. They're very active, of course, in selecting us, which is what we're seeing now, as I said, with the early appointments from this administration federally. you can judge it for yourself. I won't say more about that. But if there aren't any other questions, then I can only say we're out of time. And I appreciate that there was such a nice turnout, and I'm glad that you sort of patiently listened to me on these many subjects, all of which I think are important to me, to society, hopefully to you. So thank you.
Please give a round of applause. We're so fortunate to have Judge Scheindlin. Thank you so much.